Somewhere in northern France, tucked behind a thick wall of hedges and accessible only through the back door of a cemetery superintendent's office, there is a plot of graves that the US government does not want you to find. No names, no flag, no mention on any official map, just numbers. What happened to the men buried there, and why the military buried the story along with them, is one of the most disturbing chapters of the Second World War. Between December 7, 1941, and February 22, 1946, the United States military executed 102 of its own soldiers. That number doesn't appear in most history books. It isn't taught in schools. For decades, the identities of the men buried in that hidden French cemetery were classified, locked away in military archives, and released to the public only in 2009, after a Freedom of Information Act request finally pried open the files. The executions happened across multiple theaters of war. In total, the US military carried out 141 known wartime executions between December 1941 and early 1946. The broader figure that includes all theaters and all offenses. The specific number of 102 refers to those executed for murder and violent assault against civilians and fellow soldiers, with one additional execution, that of Eddie Slovik, carried out for desertion. 70 of the full wartime executions took place in Europe, 27 in the Mediterranean, and 21 in the Pacific. In Europe and North Africa alone, 98 men were put to death following general courts-martial, hanged or shot by firing squad for crimes committed during the war. To understand why this happened, why an army fighting for democracy chose to execute nearly 100 of its own men far from any battlefield, you first have to understand what the US military was dealing with in the years after it mobilized. In 1939, the American Army had roughly 190,000 active soldiers. By 1945, it had grown to more than 8 million. That explosion in size was unlike anything the country had managed before. Men were drafted by the millions, many of them young, poorly educated, pulled from poverty, and thrown into a military system that was itself scaling up faster than its institutions could absorb. The Army lowered its intelligence requirements for enlistment multiple times during the war. Men who would never have passed a standard fitness screening were issued weapons and uniforms and shipped overseas. With that scale came problems that no amount of training could fully contain. Violence, disorder, and criminal behavior did not disappear when men put on uniforms. And the military, operating under its own legal system, the Articles of War of 1920, had both the authority and, at times, the willingness to respond with the ultimate punishment. The crimes that led to executions were, with one famous exception, not military offenses. They were the same crimes that courts in civilian life would have tried as capital cases: murder and violent assault. The Army did not execute men for cowardice, for retreating, or for insubordination. What it executed them for was what some of those men did to civilians and fellow soldiers in the countries where they were stationed. But before we get to the statistics, the patterns, and the hidden cemetery in France, there is one case that has to come first, because it sits entirely apart from all the others. One man was executed not for violence against anyone. He was executed because he was scared, and because the Army decided to make him a permanent example. Private Eddie Slovik was born in Detroit, Michigan on February 18, 1920. He grew up poor, dropped into petty crime as a child, and spent time in prison twice before he was 22. By the time the war came, he had been classified 4F, unfit for service, because of his criminal record. Then the Army ran short of men. Draft standards were lowered. Slovik's classification was changed. In January 1944, he was called up, trained as a rifleman, and shipped to France in August to join the 28th Infantry Division, which was fighting its way through northern France toward Germany. Slovik had always said he could not handle combat. He hated firearms. He had petitioned to be assigned to a non-combat role, and the Army had refused. When he arrived at the front and heard artillery for the first time, something in him broke. He and a companion became separated from their unit in the chaos near Elbeuf, France, and fell in with a Canadian unit for 6 weeks. When they were returned to American control in early October, no charges were brought. Replacements getting lost in their first days at the front was not unusual. But Slovik, unlike almost every other soldier who had ever gone absent, decided to put his intentions in writing. He approached his company commander, said he was too frightened to serve in a rifle company, and asked to be reassigned. When the request was denied, he told his commanding officer he would run if forced to fight. Then, the following day, he did exactly that. When he surrendered himself at a nearby field kitchen, he handed over a handwritten note confessing that he had deserted and stating plainly that he would do it again if returned to the front. Multiple officers, alarmed by what they were reading, urged Slovik to destroy the note. He refused each time. A legal officer of the 28th offered him a way out, returned to his unit immediately, and faced no court-martial. Slovik refused. He was court-martialed on November 11, 1944, on charges of desertion to avoid hazardous duty. The trial lasted less than 2 hours. A 9-officer panel voted unanimously: death. Slovik had expected a prison sentence. Every other deserter he had seen punished had received a prison term. He was stunned by the verdict. He wrote a letter to General Dwight D. Eisenhower on December 9th, pleading for clemency and explaining his fear of combat in plain, unheroic terms. The timing could not have been worse. On December 16th, Germany launched its massive surprise offensive through the Ardennes, what became known as the Battle of the Bulge. American casualties mounted by the thousands. Desertion had become a systemic problem in France, with tens of thousands of soldiers going absent at various points during the campaign. Eisenhower and his senior judge advocate concluded that the moment demanded a firm message. On December 23, 1944, Eisenhower confirmed the sentence. On January 31, 1945, near the village of Sainte-Marie-aux-Mines in eastern France, a 12-man firing squad assembled. Slovik's uniform had been stripped of all insignia the night before, the standard military protocol for a dishonorable discharge. He was 24 years old. Before being led to the courtyard, Slovik made remarks to the soldiers preparing him for the execution. He told them that they were not shooting him for deserting the army. Thousands of men had done that. He said they needed to make an example out of someone, and he was it because of his criminal record. He told them they were shooting him for the bread and chewing gum he had stolen at the age of 12. He was hit by 11 bullets. 4 were immediately fatal. He died before the firing squad could reload. Slovik was buried in Plot E of the Oise American Cemetery in northern France, alongside 95 other executed American soldiers. His grave was marked with a number, not a name. His wife, Antoinette, was not told how he died until a journalist named William Bradford Hussey published the story in 1954. She petitioned every president from Truman through Carter for a pardon or the return of her husband's remains. None complied. She died in 1979, still waiting. In 1987, President Ronald Reagan ordered Slovik's remains returned to the United States. He was reburied in Detroit's Woodmere Cemetery next to his wife. Of the 21,000 American soldiers who faced desertion charges during the war, 49 received death sentences. Slovik's was the only one carried out. He remains the only American soldier executed for desertion since the Civil War. But Slovik was the exception in one critical way. He had never harmed anyone. The other 101 executions were carried out for a far darker set of reasons, and they tell a story that goes well beyond individual criminal acts. That story starts in England in the winter of 1942, with the very first American soldier to be executed on British soil. On the night of December 27, 1942, Private David Cobb of the 827 Engineer Battalion was 11 days into his deployment in Britain. He had arrived on December 16th, assigned to Desborough Camp in Northamptonshire. He had been on guard duty for hours longer than expected, through the cold, and was tired and irritable when Second Lieutenant Robert J. Cobner arrived to inspect the guardhouse and oversee a routine task. When Cobner reprimanded Cobb for his bearing and ordered him to stand at attention, Cobb responded with open defiance. Cobner ordered the sergeant of the guard to arrest him. Cobb turned his rifle on the sergeant, who backed away. Cobner, rather than standing down, stepped forward himself to take the weapon. Cobb shot him once. The bullet struck Cobner's heart. He died instantly. Cobb was 21 years old, from Dothan, Alabama. He was tried by court-martial in Cambridge on January 6, 1943. The trial lasted less than 1 day. The verdict was death. On March 12, 1943, less than 3 months after the shooting, Private David Cobb was hanged at Shepton Mallet Prison, a centuries-old facility in Somerset, England, that the U.S. Army had taken over for use as a military prison and execution site. The hangman was Thomas Pierrepoint, one of Britain's official state executioners. Because British law required that executions on British soil be carried out by a British-appointed executioner, 17 more American soldiers would follow Cobb to that same gallows before the war was over. Cobb became the first American soldier executed for a crime during World War II. He was 21 years old. His case introduced a pattern that would persist across the majority of the 102 executions that followed. An overwhelming proportion of the men put to death were black soldiers, tried before all-white court-martial panels, often for crimes against white victims, with trials that lasted hours rather than days, and defense efforts that were frequently inadequate by any standard of legal process. Of the 18 American soldiers executed at Shepton Mallet Prison during the war, over half were black. Across the European theater as a whole, the racial disproportion was stark. Black soldiers were executed for certain categories of crime at rates far exceeding their proportion of the overall force. In England specifically, research conducted decades after the war found that no white soldiers were executed for certain categories of violent crime, even in cases where evidence of guilt was comparable. The Army's own records acknowledge the speed of the proceedings. Some trials began just 5 days after the alleged crime. Some lasted a single hour. Defense counsel were often inexperienced, sometimes given only hours to prepare. Review processes were subject, in some documented cases, to improper influence from senior commanders. None of this emerged publicly during the war. The executions were not announced. The press was not invited. The Army's official position was that military justice had been served, and for decades, that was the only version of the story anyone knew. But pieces of a far more troubling picture were buried in classified files that would not be unsealed for more than 60 years. The crimes themselves were real. The victims were real. But the application of ultimate punishment, who received it and who did not, was not simply a matter of guilt and evidence. Race, rank, and the circumstances of wartime pressure shaped outcomes in ways the military was not prepared to acknowledge publicly. What happened at Shepton Mallet was the beginning. Across France, Italy, Belgium, North Africa, and the Pacific, the courts-martial continued, and the pattern held. The legal system governing American soldiers during World War II was the Articles of War, enacted by Congress in 1920. It predated modern standards of military justice by decades. Under its provisions, a general court-martial could sentence a soldier to death for murder or a serious violent offense. And that sentence required approval from the commanding general of the theater, and ultimately the President of the United States, before it could be carried out. On paper, that chain of review sounds thorough. In practice, the wartime courts operated under extraordinary pressure. When a crime occurred near an American garrison, a civilian killed, a violent assault committed, local military commanders faced immediate pressure from both the civilian population and their own chain of command to respond quickly and visibly. Host nations expected the Americans to police their own. Delay was politically costly. Trials were convened rapidly. Defense counsel was provided, a basic requirement of the system, but often the lawyer assigned had little time to review the evidence, no investigative resources, and minimal familiarity with the specific charges. In multiple documented cases, defense attorneys later stated that they had been given only days or hours to prepare for capital cases. The panels that decided the verdicts were composed entirely of officers. In an army that remained rigidly segregated throughout the war, that meant all white panels deciding the fates of black defendants in case after case. There was no requirement that a defendant's peers, in any meaningful sense of the word, sit in judgment of him. Appeals existed, but they moved within the military system, reviewed by the same chain of command that had approved the original prosecution. External oversight was minimal. The condemned had no access to civilian courts. The process from crime to execution could be measured in months, sometimes weeks. Researcher J. Robert Lilly spent years in the National Archives studying the trial transcripts of military executions in the European theater. His findings, published in academic journals in the 1990s, documented what the files themselves showed. The executed population skewed heavily. Black, the victims were overwhelmingly white, the trials were brief, and the defense efforts were often thin. 3 soldiers, in his assessment, were probably not guilty at all. 10 more were possibly not guilty. Another 24 could reasonably have received prison sentences rather than death, given the mitigating circumstances in their cases. The speed of the process is perhaps the most jarring feature when laid against any modern standard of legal scrutiny. Under the Articles of War, a court-martial could be convened and a verdict delivered within days of an alleged crime. Some proceedings that ended in death sentences ran for a single hour. There were no requirements for the kind of extended evidentiary review that civilian capital cases would demand. There was no independent judiciary. There was no appellate court outside the military chain of command. In one documented category of cases, soldiers accused of crimes in the Italian campaign, proceedings sometimes commenced within 5 days of the alleged offense. The defense counsel in several of those cases had no prior experience with capital litigation, no investigative staff, and no ability to obtain witness testimony from locations far from the garrison where the trial was held. The system had been designed for a different era, one in which the army was smaller, the crimes were simpler, and the idea of extended legal process in a theater of war was considered a luxury. By 1944, it was being applied to an institution of 8 million people, spread across multiple continents, under conditions of extreme stress and institutional pressure, with life and death hanging on proceedings that sometimes lasted less time than a routine administrative hearing. None of that was visible to the public at the time. The Army processed its dead, classified its files, and moved forward. In 1949, 4 years after the war ended, the United States Army made a decision about what to do with the bodies. The executed soldiers had been buried individually, near the sites of their executions, in temporary graves in England, France, Belgium, Germany, Italy, and Algeria. Now, the Army wanted to consolidate. They chose a location in northern France, the Oise-Ain American Cemetery and Memorial, a World War I cemetery located about 70 miles northeast of Paris, containing the graves of more than 6,000 Americans who had died fighting in that region in 1918. Plots A through D held those honored dead. Across the road, outside the walls of the main cemetery, through a thick border of hedges, the Army created a 5th plot, Plot E. The men reinterred in Plot E had all been dishonorably discharged from the Army the day before their executions, a standard procedure that legally stripped them of their status as soldiers. Their graves were marked not with names, but with numbers, 1 through 96, flat stone squares the size of index cards, pressed into the grass in 4 rows. A single small granite cross stood at one end. No American flag was permitted to fly over the section. The plot was not mentioned on the cemetery's official website, in its guidebooks, or on its maps. The only way to access it was through a door in the back of the superintendent's office, and visitors were actively discouraged. One cemetery employee described it, in remarks that have been widely quoted since, as a house of shame and a perfect anti-memorial. The names of the men buried there were not released to the public until 2009, when a Freedom of Information Act request finally produced a table matching grave numbers to identities. For 60 years, their families, whatever remained of them, had no way to confirm where their sons, brothers, or fathers lay. Among the 94 men currently interred in Plot E is Louis Till, a name most people would not recognize on its own, but whose connection to American history runs far deeper than his grave number suggests. Till was a soldier convicted of murder and a serious violent offense against civilians in Italy in 1945. He was hanged on July 2, 1945, at Aversar, Italy. His remains were later moved to Plot E in 1949 when the plot was consolidated. His son, Emmett Till, was 14 years old when he was murdered in Mississippi in 1955, a killing that became one of the defining moments of the American Civil Rights Movement. After Emmett's killers were acquitted, Mississippi Senator James Eastland obtained Louis Till's classified military file and leaked it to the press. surfacing the story of his father's execution in a manner that many historians have since described as a deliberate attempt to undermine the Till family's credibility during one of the most racially charged moments in modern American history. The Army had kept the file classified. It was political pressure, not official disclosure, that put it into the public domain. The story of Plot E does not end in France. Its threads run through decades of American life. By the time the full picture of military executions during World War II had been reconstructed by researchers and journalists working from declassified files, the pattern was impossible to ignore. Of the 98 men executed in the European theater for murder or violent offense, approximately 79% were black soldiers, in an army where black soldiers made up around 10% of the total force. No white soldiers in the European theater were executed for certain categories of assault crime during the entire war. Even in cases where the evidence against white defendants was comparable to cases in which black soldiers were put to death, the Army's own records showed that speed was a hallmark of proceedings where black defendants faced capital charges. White defendants in similar circumstances were more likely to receive life sentences or to have death sentences commuted on review. This was not a coincidence of geography or circumstance. It reflected the structure of an institution that was itself fully segregated, where black soldiers served in separate units, were commanded almost entirely by white officers, and had no recourse within the system to challenge that structure. The Army's treatment of its black soldiers during World War II has been documented extensively in the decades since. The discrimination in assignments, the inferior equipment, the routine indignities of serving in a Jim Crow institution sent to fight a war against racial supremacy in Europe. The execution statistics were the extreme end of that same spectrum. After the war, the Army commissioned its own review of the court-martial system. The review acknowledged serious deficiencies in due process, the speed of proceedings, the quality of defense representation, and the consistency of sentencing. These findings contributed directly to the passage of the Uniform Code of Military Justice in 1950, a comprehensive overhaul of the military legal system that introduced stronger protections for defendants, clearer standards for evidence, and a more independent review process. The reforms came too late for the 102 men who had already been executed. One of the most striking aspects of this history is not simply what happened, it is how carefully the Army managed the information about what happened. The executions themselves were not publicly announced. The press was barred. The condemned men's families were notified that their soldiers had been executed under military authority. But in many cases, the full circumstances were not disclosed. Wives and mothers who attempted to learn more were met with silence or bureaucratic obstruction. When journalist William Bradford Ue published his account of Eddie Slovik's case in 1954, it was the first time most Americans had ever heard that the Army had executed any of its own soldiers during the war. The book sold millions of copies. The shock was genuine, not because people doubted that the Army had its own legal system, but because the execution of a man for desertion, with no violence attached, felt categorically different from anything the public had been told. What Ue's book did not cover, because the files were not yet available, was everything else. The 101 other men, the pattern of who they were, the conditions of their trials, the question of whether every one of those 102 deaths had actually served justice. The classified files on military executions during World War II were held in the National Archives. Access was restricted for decades under various national security provisions. When researchers began gaining access in the 1980s and 1990s, what they found was not a record of clean and impartial justice. It was a record of a system under extreme pressure, making irreversible decisions with inadequate process, and then locking the results away. The families of the executed men occupied a particular kind of silence during those decades. Most had been told only that their soldier had been executed under military authority. The detailed trial records, the names of the officers who approved the sentences, the specifics of the crimes, and the evidence presented, all of it remained inaccessible. Wives who wrote to the Army asking for information received terse form letters. Mothers who tried to locate their sons' graves were told only that the remains were held in a military cemetery overseas. That silence lasted for many of those families until the people who had been waiting were themselves gone. The Army's acknowledgement of this history has been partial and slow, The Uniform Code of Military Justice addressed the structural deficiencies. The opening of the archives allowed the academic and journalistic record to be built. The 2009 Freedom of Information release of Plot E's records gave families and historians the names they had spent decades trying to find. But there has been no formal review of individual cases, no official process for examining whether specific verdicts should be reconsidered. The men in Plot E remain legally where they were placed, dishonored, numbered, and officially off the map. In a field in northern France, 94 numbered stones lie in 4 rows, facing away from the cemetery that holds America's honored dead. There is no official acknowledgement of who is there. There is no path to the entrance. The American flag does not fly over the ground. What rests in Plot E is a compressed and largely concealed chapter of American military history, one that encompasses criminal violence, racial disparity in the application of military law, the consequences of building an 8 million-man army in 4 years, and the choices that institutions make about which truths they are willing to carry publicly. The men who committed acts of murder and violent assault against civilians and fellow soldiers were guilty of serious crimes. That fact is not in dispute. The victims they left behind, in English villages, French towns, Italian cities, in North African garrison towns, were real people whose suffering was real. But justice was served is a claim that depends entirely on the process by which it was delivered. And for a significant number of the 102 cases, the process was flawed in ways that the Army later acknowledged when it rewrote its entire legal code. Eddie Slovik's case became a public story through a journalist and a best-selling book. The other 101 cases remained in classified archives for decades. The full record is still being reconstructed by historians who work from documents rather than from any official account. The post-war reforms to military justice, the UCMJ of 1950, the stronger review procedures, the increased protections for defendants, were real and meaningful improvements. They acknowledged in their substance, if not in any explicit statement, that something in the wartime system had gone wrong. The soldiers buried in Plot E cannot be reached by those reforms. Their dishonorable discharges have never been reviewed. Their cases have never been reopened. Their graves still carry numbers instead of names for anyone who approaches without a list, obtained through a Freedom of Information request. The question of what those numbers represent, straightforward justice, institutional failure, racial inequity, or some irreducible combination of all three, is one that American history has not yet formally answered. What is certain is that the answer is buried in France, in a field the official maps don't show, behind a hedge that most visitors to the Oise-Assen Cemetery will never know is there. If you enjoyed this video, please like and subscribe to our channel so you never miss out on more history documentaries.